Welcome to Access and Privacy Online. I'm Patrick Farnsworth. This is a segment of our end-of-year discussion with FIPA researcher Ryan Rutley. He explains why Part C-4 of Bill C-4 is a direct attack on the privacy of Canadians and how his research intersects with FIPA's call to action. Tune in to hear the full discussion in the coming weeks. Cheers. Now we're seeing all these developments with Bill C-4. Of course, FIPA has been spending a great deal of time on that. And also just how political parties in general are trying to skirt a lot of this, right? They're really trying to avoid, accountability and transparency, and really kind of almost exercising themselves from that sort of process. So, Ryan, from your experience as a student as well as working in FIPA and working on this, could you kind of give us a rundown of your work regarding that and just your general interpretations of where that's coming from and where that's leading?
Mm-hmm. Yeah, so in my previous co-op term, I got to work on the Liberal Parties versus Complainants case. It's a case that originated as a complaint to the BC Office of Information Privacy Commissioner, has since gone to the courts. The complainants argued that BC's FIPA legislation applies to political parties. So they are, due to the wording of the private sector access and privacy law, political parties are included in that definition. Now, it's already been established that provincial political parties are covered. This case is determining whether federal political parties are also covered. In and amongst that process, when I first came to it, there had already been some revisions to the Canada Elections Act seeking to exclude political parties from BC's legislation. The court didn't buy it. The case continued through the courts, and the BC Supreme Court found at that stage that the commissioner was right, that BC's law applies to federal political parties. They are an organization of some kind. It applies, no argument. So in the time between that term and this one, I wrote my major paper for advanced legal research and writing on this topic and bringing in some political theory into how the incentives work to protect political parties from privacy and access from that kind of supervision that every other organization, we often say, like Tim Hortons is subject to more scrutiny than political parties are. There are, various political theories about how political parties should be understood. In Canada, they're unincorporated associations. The courts don't really like to constrain what unincorporated associations are, what they're subject to. They are considered purely voluntary, a bunch of citizens getting together and doing something on their own power. There's another view of it that they're more like public utilities and that they should be regulated like public utilities because they facilitate the democratic process. Canada has leaned towards the laissez-faire approach. There are some cases demonstrating that if anybody's interested, they can email me and I can tell you more about that. So I argued in that paper that the court should be braver about applying accountability and applying these types of laws to political parties. Bill C-4 would explicitly overwrite any possibility of using that avenue to apply accountability to them. So part of the changes in Bill C-4 would explicitly exclude federal political parties from any provincial regulation. And it would apply all of the changes retroactively to, I believe, the year 2000, Jason.
Yep.
Effectively rewriting history on this legislation. And there has not been such a brazen attempt to explicitly exclude themselves from accountability. Now, there's some political philosophy stuff about, well, MPs are representing their constituents and they're not acting as part of their political party, so we can't say the political parties are doing this. But I think the party system in Canada is pretty observable. And I think it's difficult to make that case that we shouldn't at least be concerned that political parties are acting in the person of the MP to advance their own interests. Go ahead.
No, I think I'm just curious because, this became a huge red flag and something that FIPA we've been talking about, and we've been encouraging listeners every episode at the end, And in the show notes, like, we really want you to, make your voices heard, that this is not okay.
Mhm.
The precedent this sets is really disturbing.
And the
So
interesting
yeah, I
thing,
mean,
if I
yeah,
may, and C4 is not a privacy or access bill. It's not an elections bill. It is related to affordability. And
yeah,
part of what is so galling about this, to me at least, is that this isn't even there's not even a fig leaf as to how this relates to affordability. And if it's part of a overall amendment of the Elections Act, okay. If it's related to if it stands on its own in public debate, that's one thing. But to import it into a bill that's related to something of great national importance without highlighting and putting this section up to scrutiny, it doesn't feel like transparency. I can say that.
Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.